Good morning. Good morning. If everyone's ready, we'll start the program. So good morning to all of our participants who have joined us for the 2020 People's Law School at Baylor Law. Thank you for being on our Zoom webinar. The course, The Wills and Estate Planning with Mr. James Rainey will shortly begin. But before, I have a few reminders. First, this program is being recorded. Links to all of today's video will be available on People's Law School page, and I will drop the link below. Second, if you have any questions for our presenters, please use the Q&A feature to pose your questions. We will try to select the questions that are likely to be interesting to most participants, and we'll do our best to get as many questions as time permits. I apologize in advance if we are unable to get to your question. Finally, just a reminder that the presenters here are not your lawyer. If you have a legal issue, please consult an attorney. All right, Mr. Rainey, if you are ready to begin, you can begin at any time.
All right, good morning, everybody. I'm James Rainey. Thanks for showing up and visiting today on our Zoom presentation for the People's Law School. I really can't see all who's participating, but our office is an elder law, estate planning, probate, guardianship, special needs planning law firm. We handle cases all over Central Texas, from Austin to the Fort Worth area, but the large majority of our clients are, of course, here in the greater Waco area. And I've been asked, and I've had the privilege to do this presentation for Baylor's People's Law School for the last several years. And so today we're going to visit a little bit about wills and estate planning, kind of go through the basics and things that would be really good for you to have a kind of a basic knowledge and understanding about when you're thinking about estate planning, when you're reviewing your estate planning, when you're changing it. And just, a lot of these things you may already know, but hopefully there'll be a few new things and maybe a little bit of a new nuance on some of the things that you might want to consider doing for your estate planning, or your parents or your family and friends estate planning. Make sure that if you have questions, I'm going to leave some time at the end. I've got an hour, but I'll probably just go around 45 minutes or so. And that way we have 15 minutes to answer questions. And if we don't, then you'll have some free time back. I'm going to start by sharing my screen. And we're going to go through some slides, and I'll just visit with you as we go through these slides. And Macy, if it doesn't show the right screen, let me know, okay? All right, so you guys should be seeing a nice slide saying wills and estate planning, James Rainey. So let's get started. Let's talk about when we do estate planning, what we're talking about is planning for our property and even planning for ourselves in the event something happens to us and we become disabled, we become very ill, we get dementia, Alzheimer's, or hurt in a car wreck, and planning for what happens to our stuff and our loved ones when we die. Right? So we're kind of looking at both. What happens if we're alive? How does somebody help take care of us? And then what happens, most importantly, when we die? What happens to our property? Who's going to get it? How do we want them to get it? Do we want any restrictions? And do we want to make sure the right people get the right stuff? And so some things to understand is there is a distinction in property in Texas. So in Texas, we have a community property state. Everything, if there's a married couple, is presumed to be community property, meaning that the husband and wife and the married couple own it jointly. That's the presumption in Texas. But we do have separate property in Texas. We just have the burden of the proof as the spouse to show that something is separate property. And it's not always very difficult to show it's separate property at all. We just have to say, hey, this is separate, and this is what makes it separate property. Also, it's important to note that there are a difference in Texas between probate property and non-probate property, all right? Your will is very important, but your will controls probate property only. Non-probate property is not controlled by your will. So let's talk about separate versus community property. Separate property, okay, the initial presumption is everything's community property, right? So we got to show that it's separate if we want it to be separate property. And so separate property is property that we own or I owned before I got married. Now the key here I don't have on the slide is that I kept it separate after I got married. I didn't give part of it to my wife. I didn't commingle it with community funds. I didn't do something to change the character. It was my separate property when I got married, and it stayed separate after I was married. So if I had money like $50,000 in a savings account, we get married, I keep my $50,000 in my savings account in my name only, then it stays separate property belonging to me. Now, if I put my wife's name on it, then I'm question becomes, am I commingling it, or am I giving her half? Those types of questions start arising. If I receive property as a gift from a parent or a friend or a loved one, or if I inherit property, then that is separate property. All right. This gets really tricky, especially the inheritance part. Okay, so if I am married to my wife for 35 years, her parents die or my parents die, and one of us inherits their house, the parents' house, or the parents' farmland, or money from the parents. That inheritance to me from my deceased parents is my separate property, even though my wife and I have been married for 30 or 40 years. My inheritance is my separate property. And if I keep it separate, it stays my separate property at that point. And that's really can be a problem. And I have families come in to see me where the husband or wife had inherited property from their parents. They just assumed that when they died, that their spouse would get everything they owned, and they died without a will. And that's not what happens. Okay. Their separate property does not go automatically to their spouse. It gets split between them and their kids and their surviving spouse. And so they don't understand that, and they didn't do a will. So it's very important that we identify what's separate property versus what's community property. I can also convert property by agreement. So my $50,000 or that land I inherit, it's my separate property. I can make an agreement with my wife. We sign it. It has to be in writing. And we agree that this property is now community property. It did not always used to be that way in Texas, but it's been that way for a few years now. And finally, mutation. My $50,000 I mentioned a few minutes ago, if I take it and buy a house with it, or I buy a car with it, and I put it in my name only, that is my separate property because I bought it with separate property funds. Everything else is community property. It's owned by both spouses. It's considered joint property. And we go forward as co-owners of that property. If a person, we've already talked about the presumption of community property. So now let's talk about non-probate versus probate property. So in Texas, property that isn't otherwise arranged for passing to be transferred on death passes by probate. Okay, so in Texas, we can set up an arrangement to have whatever we are own to be transferred directly to somebody by contract when we die. And if we do that, that's a non-probate item. Everything else that isn't specifically arranged for by contract to pass when I die is considered a probate item. And so that's really important. And our will controls all of our probate property. So if I make a particular arrangement to transfer a particular piece of property or money by contract to somebody when I die, then that's going to pass outside the probate process, and it's not a probate asset. Examples of non-probate assets are some of the ones we normally think of are life insurance, retirement and IRA benefits. And so on those types of accounts, I name a beneficiary. So I sign a contract with the company that has those funds that says, when I die, I want you to deliver this money to these particular persons or to this person. So if I have life insurance, I might say, and fill out the form and sign the contract that says, give it to my wife, Elisa, when I die. And so that property is going to transfer directly to her on death once she kind of proves that I've died, that she is Elisa Rainey, and she fills out the proper forms. Same way with retirement and IRA benefits. A trust is also a way by contract to set up assets to transfer outside of probate when we die. We'll talk more in detail about that. And often our bank accounts, we can set them up as joint tenants with right of survivorship. So if we're married or we want to set it up with a child so that it automatically transfers to that person when we die that we share the account with. We can also name them as a beneficiary instead of a joint tenant. So let's talk about a will. right? So do I need a will? The answer is yes. Everybody in Texas needs a will. So probate in Texas is not terrible. It's not super expensive and it doesn't take super long unless you have a very complicated estate. Or unless you have kids who just decide to fight with each other for no reason and make it complicated. All right. But if you have a well-written will that meets all of the requirements and it needs to be probated, it's not terribly wrong and it's not terribly expensive. And you can get through the probate process pretty quickly. And so with our will, we get to decide who gets our property. We get to name our beneficiaries, or sometimes they're called our devisees. These are the people who get property from us through our will. And we can choose whoever we want. I mean, anybody at all. I worked on a probate case a few years ago now, where a gentleman ended up leaving his wife for a mistress. They were separated, never divorced. He does a new will and he leaves his $1.5 million ranch to his mistress in a different county outside of Waco. And he had 3 daughters and he left them each money in bank accounts, but not the equivalent of $1.5 million each by any stretch of the imagination. And so then the question becomes, can he do that? And yes, he can, as long as he's of sound mind and it's his property. He can leave it to whoever he wants to. It's the same for us, right? We can do whatever we want with our property, to our wife, to our kids. Sometimes I have people saying, I would like to leave everything to just one child, or I'd like to leave everything just to my kids and not to my spouse. Are we legally allowed to do that? Yes, absolutely. We can also choose the executor. That's the person who's going to come in and take care of making sure that our will is probated, that our property is taken care of, that our debts are paid, and the money is distributed to people pursuant to our will. If we have minor children, we can tell the court who we want to be appointed minor guardian for our minor children in case we died early. We can do debt planning, tax planning inside our will. If we have a giant estate, we're going to be careful and maybe we might want to do some bypass trusts or something. And we can even put powers of appointment on our will that relates to some specific other types of planning that we don't have time to talk about today. It's important to know that once you have a last will and testament, like I mentioned already, it does have to be probated when we die. Sometimes I have clients come in and say, well, I'm the executor in the will. Can't I do this? The bank won't let me have the money. Well, the will says, this is who I want to be my executor. The will still has to be probated with the probate court. And then the judge still has to issue a certificate called letters of testamentary that makes you and appoints you the actual executor if you're serving as executor under the will. So the will is the roadmap and it's your instructions and it tells the court what you want to happen, but the executor doesn't have official power to do that until they go in front of the judge and get appointed executor. And so in our will, we want to make sure that we waive the bond for our executor unless we're concerned about, their trustworthiness or their management abilities of money, then we might want to require a bond. And again, their job is to gather our assets, pay off our debts, and then deliver them according to the terms of our will as quickly as possible. Now, I often get questions about a trust. Can't we just do a trust? Can we avoid probate with a trust? The answer is yes, we certainly can avoid probate with a trust. And a trust is certainly a good way to do your estate plan. Is it better than a will planning based type of plan? No, I don't think so. Not in Texas, because remember the probate process, if you have a good will and not an overly complicated estate, it isn't very expensive or very time consuming. But it is a great way to do your plan. Having a living trust works very well, provided that you use it properly. A lot of people don't use it properly, and so they don't really get the advantage of having the trust. But again, with a trust, we can do all of our planning. We can plan for taxes. We can arrange for our property to be transferred or managed for somebody else when we die. We can set it up to avoid any kind of probate. And sometimes we can protect assets from creditors. So if we're giving something to a child and they have creditors, we wouldn't give it to them outright. We would set up another subtrust maybe for that child and have someone appointed as trustee to manage that money for that child. And that would keep the creditors from just taking all of it and paying, themselves the money owed by our child. Uh, Trusts, are considered inter vivos or testamentary. Inter vivos means it's a trust created during our lifetime, and it might be revocable, usually is revocable, but occasionally we make it non-revocable or irrevocable. And then we have testamentary trusts. A testamentary trust is a trust that we create in our will. So like we were talking about a few minutes ago, when we make our will, we can be pretty flexible and say who gets our property, and we can determine how they get our property. A lot of way to do that is to create a trust in our will that says who's going to get our property, who's going to manage it for them, what the terms and conditions are that they're supposed to be managed for their benefit. Usually, that trust we create in our will is irrevocable once we die and it springs into action. I don't guess it has to be, but almost always is. So the inter vivos trust is made while the grantor or trustor is alive. That's the person who makes the trust. Again, when we make the trust today that we're going to use, we can make it revocable or irrevocable. Depends on what our goals are and whether or not we want the flexibility to change and amend that trust later. Very common types of trusts that we see, that we do, and that we hear about it's called a family trust or a living trust. And when we make a trust, we still need a will, okay? Because when we die, we might own property that's not inside the trust. And so we still need to make arrangements for that property to be transferred on our death to wherever we want it to go. Often we use what's called a pour over will, right? So we're going to take the property that's not in the trust, probate it, and send it to the trust. And so we're pouring it over into the trust. So it's called a pour over will. It doesn't not have to be a pour over will. We could create a trust, and then we could say we don't want something in the trust and have a will control it separately and independently of the trust. But usually when you do a family trust or a living trust, most often you use a pour over will that sends everything to the trust if there has to be a probate. Also, it's very common to do trusts called inter vivos trust or inter vivos trusts now while we're alive for special needs for our beneficiaries, for children that we have special needs or family members that we want to kind of provide for now and even after we die. All right. When we use an inter vivos trust, more like a family trust or a living trust, this will be a typical setup. We establish a trust document, and in our trust document, we're going to name a trustee. The trustee considered is like a manager. Their job is to manage the trust and the assets and to follow the instructions that we put in our trust document. We're going to name a successor trustee, maybe even 2 or 3 successor trustees. These folks will take over when it's their turn, when the trustee dies or can no longer serve as trustee, to be the manager of the assets in the trust and follow the instructions. We're going to name the beneficiaries of the trust. These are the people who get the benefit of whatever the trust owns. And this will be, I didn't put on here, but the grantor or the trustor is the people who make the trust. So an example would be if I made a trust, my wife and I made a trust, we would be the grantors or the trustors. If we're setting up a family trust, typically we're going to name ourselves as trustees. So we're going to create a trust. We're going to name ourselves as trustees. We're going to name maybe our children as successor trustees when we both die. We're going to be the beneficiaries ourselves. We're going to say, I create a trust. I name myself as manager or trustee of my trust, and I'm the beneficiary of my trust. So my instruction to me as trustee is going to be, hey, do whatever you want with your assets in this trust until you die or until both of us have died. Is going to be my instructions. All right. And then my instructions in the trust is going to be say, once I die, this trust is then for the benefit of my wife, if she's still alive. If she's not alive, then I want everything to be delivered to my 2 boys. And here's the successor trustee. You, successor trustee, are to sell my house and add all my money together and split it equally between my 2 sons. That might be the instruction. And so that would work really well. Now that works really well, provided that, as we see in number 3, that I transferred all of my assets into the trust while I was alive. So if my wife and I create this trust and we want it to work like that, we actually have to take our house, our cars, our checking account, our savings account, our stock accounts, mineral interests we might own, the ranch, whatever else that we have, and transfer it all into the trust. Because if the trust doesn't own these documents, these assets, then when we die, they can't follow my instructions to sell property and deliver it to my kids because they, as trustee, don't have possession of that asset. So then the will still becomes important. All right. And so I have all the time families come to see me and they have a trust set up, but they may only have the Edward Jones account in it. They don't have the UBS account or the checking or the savings or the house in it. And there's no beneficiaries named on the accounts. So we still have to do a probate, even though they had a trust with some assets in it. The nice thing about a trust is in our instructions, we can pretty much say what we want, right? So if my wife and I set up a trust, we could agree that when the first one of us dies, it becomes irrevocable and it can't be changed. So then if I died first and my wife finds new Mr. Right and gets married and accumulates new assets, great. They can dispose of their new assets however they want. But my one half of the assets that were in the trust can't be moved or changed. And they could maybe be used for my wife's benefit, but then whatever's left over will go to my kids. So I can kind of try to make sure something is set up to be remainder or leftover for my kids. A testamentary trust is a type of trust that we'll do inside our wills. And we do that a lot for people. A lot of people don't think about doing testamentary trusts, but they can be very, very useful. So here's 4 types of trusts that will often create inside the will and become effective when we die, right? But the trust only comes from the will and only becomes effective when we die and the will is probated. A special needs trust for children with disabilities, okay? We'll often create a third-party inter vivos trust, but we'll also create one in the will. And sometimes we'll just create it in the will only. And it says, when I die, I want half of my property to go to the benefit of my disabled child, but I want it to go in trust. And I want to name somebody as trustee. It could be a sibling, a sister of mine, or a bank. And they're going to manage the money then for my child with disabilities. And this could be because my child with disabilities is not capable of managing their property, but it could also be because they're on Medicaid and they're on SSI and I don't want them to lose their benefits. So I don't want them to inherit money outright. And as a result, I want it to go into a special kind of trust that will preserve property for them. All right. So we'll often do that inside the will. Another trust that we often do inside of the will is a special needs trust for the surviving spouse. This is a special kind of trust that we use quite a bit when we're concerned about long-term care expenses and one spouse dies and how is the surviving spouse going to pay for nursing home care later. What we can do is send one half of the community property assets and my special property when I die to a trust for the benefit of my spouse, for my wife. And then that money that gets put in that trust for my wife when I die, it is now no longer considered my wife's asset, and it doesn't count as an asset in the event she needs to qualify for Medicaid to pay for nursing home care, or it doesn't count for medical expenses. And as a result, one half of our joint property is now exempt, no longer counts for those purposes because it's in a special needs trust for my wife. And the kids or a bank could manage it for her benefit so they could still give her money from that trust as needed. And then whatever's left over when she dies goes to our children. So we set those up quite a bit. Another type of trust that we see a lot in a will is a trust for the spouse and then the remainder for the kids. And that's kind of the same scenario I mentioned a few minutes ago. So that would be for spouses in situations where, hey, we're concerned that once I die, my surviving spouse, in this case, my wife, gets remarried. I don't want her to leave everything to her new husband because then when she dies, he may leave everything to his children and nothing to my children, right? Or they may spend it all up and leave nothing for my kids. So I can create a trust in my will, send it my half of everything into that special trust, allow some of it to be used for my surviving wife and whatever's left over to be sent to my kids when she dies. And last, we can also use a trust just straight for our children only. When we die, we say any money that this kid inherits goes into the trust, and it's going to be used until they reach a certain age out of the trust or forever. We can decide whatever we want. And if our kids are minors, we definitely don't want them to inherit a large chunk of money. We want it to go in a trust till they turn 21 or 25. And then I have plenty of families whose kids don't manage money well, and or their spouse spends money too well, whatever the case might be. And so we might put money in trust for those reasons. Just go over basically just for a few minutes, estate and gift taxes, because I get questions about that. So when we die, if we have a large estate, then our estate might have to pay a tax to the government because and based solely on the value of our assets when we died. All right. And that tax is 40% of the estate. So it's a significant tax. Now, right now, in order to trigger an estate tax, my estate has to be worth about $12 million. About $11 million. Okay. So, and it's joint between the two of us. So double that if you're married. Okay. $22 million. So, the odds, I think it's actually 12 million in 2022. It's gone up this year. So, that's per person. So 24 million if you're married. So I don't have $24 million. My wife and I don't have that. So we don't have to worry about estate taxes. All right. But in 2026, that's going to drop in half. All right. So it's going to go from 12 million per person to 6 million per person. But still, the large majority of us don't have $12 million if we're married, $6 million each if we're single. And so if we don't have that much money or approaching that much money, then estate taxes really aren't a concern for us. But if we do have that much money, then we are concerned about it, because when we die, 40% of whatever's over the limit goes as a tax. So we really want to be kind of aware of that. It's also important to note that, since I have 12 million and my wife has 12 million, when I die, if I don't have any planning in place, it's okay. My 12 million will go to my wife, and she might have to make an election to get it on her tax return, but it goes to her. Now she can have a $24 million estate tax-free, and when she dies. Anything over the 24 million, if she got that deduction, then would be taxed at 40%. But remember, in 2026, that cuts in half. So if we have those kinds of numbers for a couple, especially, we'll often want to recommend that they at least make a bypass trust in their will. And so a bypass trust sends the first spouse who dies, their share of money into a trust, a testamentary trust, like we talked about a few minutes ago. It sends that money into a trust. And that trust will have special provisions that says the income can be used for the surviving spouse. 5% or $5,000 a year, whichever is greater, can be used for the wife. And then if the wife needs it for certain purposes, she can take money out of that trust. But it can't just be used freely for the wife. It has to be with some restrictions. And then when the second spouse, in my scenario, the wife dies, everything goes to the kids. And so that works really good. So in our example here, let's say husband and wife have $19 million community property estate. Each spouse then owns $9.5 million. Our husband is the first one to die. And the tax exempt amount is $10 million instead of $12 million, right? So the husband dies, his $9.5 million goes to the wife. The wife now owns $19 million. And if we go over under this example, 40% of the amount over then would be $3.6 million in taxes. If we did a bypass trust, when the husband dies, his share goes into the bypass trust to benefit the wife under certain conditions, and then go to the kids when he dies. So the wife keeps her half, 9.5 million. The wife benefits from the trust to some extent. And then when she dies, there's no estate tax. And so we avoid her climbing over and above the tax limit. And so bypass trust could work really well, because remember, the 9.5 million that went into the bypass trust would presumably be invested. and will grow with interest in stocks and real estate, however it's invested. And so it's going to grow to more than $9.5 million. So it won't be part of the wife's estate when she dies. It'll go straight to the kids and it'll avoid estate tax. Give taxes, just so we know, the way our system works is we can give away $15,000 per month, per person per year, as many times as we want, and there's no gift tax. We don't even have to report it. But if I give away more than that, then what happens is I have to report that I gave away more than $15,000 to somebody. So if I give my son $25,000, I'm supposed to do a gift tax return that says I gave him $10,000 over the limit. And then the IRS keeps track of that. And then when the total value of my gifts and my estate reach $12 million and I'm still alive, then I may owe a 40% gift tax. So it's a combination. Now, when I die, they're going to go back and look at the gifts I made, add that to the value of my estate to determine whether or not I reached the $12 million. The Secure Act. The Secure Act passed at the end of 2019. Probably everybody has heard about it by now, but just in case you haven't, you should know that if you have an IRA and you're working, you can continue to contribute to your IRA past the age of 70 and a half, as long as you're working. You used to have to, it used to be that you couldn't contribute. You could keep working, you just couldn't contribute anymore to your IRA. Now you can. And as long as you're working, you can continue to contribute to your IRA. Also, you used to have to start taking money out when you turned 70 and a half. Now you do not have to start taking money out of your IRA until you turn 72. But when you turn 72, you have to take money out every year so that you pay taxes on it. The government wants to finally start getting some taxes on this money that you've been saving all of your life. And you should know that if you inherit an IRA, and it's not from your spouse, it's from your parents, you only have 10 years to get that money out and pay taxes on it. You can't stretch it over your life expectancy anymore. It used to be if mom died, you inherited her IRA, you could stretch it over your life expectancy and just take out a required distribution each year. But now you have to take all of it out within a 10-year period. And from my understanding, it doesn't matter how you choose to do that. You could leave it all in there for 10 years and then take it out. You can divide it up over 10 years, or you could take it all out immediately. Let's talk about some other estate planning tools that you guys need to know about. Everybody, I think, knows about powers of attorney. Everyone should have a power of attorney. And everybody should give some thought to their power of attorney. They shouldn't just print something off the internet and sign it. You need to give some thought to that. Is it going to be a general power of attorney, a special power of attorney, or like I have on here, is it going to include extra powers and planning, allowing your agent to make gifts of your money to themselves and or their family members? Is it going to allow your agent to make Medicaid planning in case you need nursing home care? Is it going to allow them to change bank accounts, move bank accounts around, change beneficiary designations? Or is it going to be very limited? You can only use this for these purposes and nothing else. All right, that's very, some thought needs to go into your power of attorney. A lot of what you would allow is going to depend on your age and on your health, right? If you're 80, you're going to want more powers. If you're 32, you're probably going to want them to have less power. So all of that needs to go into your consideration in drafting, signing, and making a power of attorney. It needs to be durable. Durable means that it has a sentence in it that says it remains valid if I become incapacitated. So if I fall over, hit my head, and I'm no longer capable of making business decisions, it's still a valid document. You can choose the effective date. Do you want it effective immediately? Do you want it to become effective later upon a subsequent capacity? Do you want it to be effective on a certain actual date and time? You can also choose an end date if you would like to put an end date on it. And sometimes I do that. When I was in the Army JAG Corps, we used to put end dates on these powers of attorneys for our soldiers all the time. So that needs to be given some thought. Medical power of attorney, same thing. You need to give some thought to that. Who will make medical decisions for you if suddenly you can't, right? if suddenly you were in a car wreck again, fell and had an accident, you got old and suddenly have dementia or Alzheimer's, who's going to make medical decisions for you? You decide that now while you're healthy and you put it in writing. Both of these powers of attorney are very helpful, and they give your agent the ability to really help take care of you while you're alive, but you can't do it yourself or you need help. But please remember, these are your powers of attorney. You can modify them, you can change them, you can amend them anytime you want. I have people say things like, I'm the power of attorney. Mom's going to go to the doctor and do this and this. No, your agent is your helper. Your agent is not your boss. And for some reason, somehow that often gets confused. And people think that because they're the agent on a power of attorney, they're now their parent's boss or their spouse's boss. And that's not how it works. Your agent is your helper, and you can change that power of attorney anytime you want. A directive to physician is also called a living will. This is where you get to decide today, while we're healthy, that if we find ourselves in an unfortunate situation where we're otherwise not alive, we're terminal, and the only thing keeping us alive is a machine or a feeding tube or something like that, then we're going to be like, I don't want to be kept alive like that. Let me go. And so we make that decision in writing today. Yes, I do get the question a lot. Well, can't my agent on my medical power of attorney just decide that when the time comes? The answer is yes. So if you don't do a directive to physician or living will, then you'll leave that burden on your agent on the medical power of attorney. So I have had personal experience, and our clients that come in and see us all the time, I think as a matter of course, you should do this document if you do not want to be kept alive on a machine, because it puts it in writing, it's signed by you, it's notarized, and you're telling your family, pull the plug when I die. And it makes it a little more comfortable for them to actually pull the plug on you, because you made the decision and you did it while you were healthy, and they know that they're following your wishes. And you can say, well, I tell them that. It's not the same. It's not the same if it's in writing when the time comes. So that's another reason to do it. Out of hospital DNR is another document that we'll do from time to time or help clients get and do. There is a difference between a DNR and a directive to physician. A directive to physician, which is the living will, talks about your general condition is you're otherwise terminal, and the only thing is keeping you alive is something, like a machine. The DNR says that if my heart stops, all of a sudden my heart is no longer beating, then, and I fall over, right? I don't want you to help me. I don't want you to run over, drop to the ground and start giving me CPR. Do not do that. Do not grab that defibrillator hanging on the wall and come over and shock me. I want to die. So when you do a DNR, that's what that says. So usually we see these in situations where someone's bedridden in a nursing home or at home and they're done. They don't want to be kept alive if they have a heart attack and their heart stops. I have on occasion have had people want to do them while they're alive and healthy because they're very sick. So healthy is not right, but while they're alive and out and about because they're very sick and they're done. So I've had that happen. But again, it has to be prominently displayed. And if the EMT shows up, if it's not immediately like tattooed to your forehead or something, they're going to give you CPR. A designation of guardian is a document that's very important for everybody who's listening who has a blended family, all right, a second marriage, stepchildren, even children that can't get along. If you're a traditional family, kids, just husband and wife, and their kids don't get along, then we probably want to consider doing a designation of guardian. So a designation of guardian says, hey, if at some point the court is having to decide to appoint a guardian over me because someone's trying to get guardian over me, this is who I want it to be. I want it to be my wife. And if my wife's not able to do it, I want it to be my third child, not my oldest child who's too bossy. We can put that in writing now. And if the time comes that my stepchildren and second spouse are fighting over who gets to take care of me, I've already put it in writing, and that's most likely, overwhelmingly, what the judge will do, and that's who they'll appoint. So it avoids a guardianship fight. Likewise, same situation, blended families. Then we want to do probably designation of agent for the disposition of remains. We get to decide in writing who will take charge of our body and take care of it. Make sure it gets buried or make sure it gets cremated. And then if it gets cremated, where does the ashes go? Or if it gets buried, where does it get buried at? Does my body get buried next to my first wife? Or does my body get buried next to my second wife's husband, where she hopes to be buried later? Those types of things are things that we can put in writing and make arrangements for now so that my kids don't fight each other, or my second wife and my kids don't fight about. This is very helpful. An enhanced life estate deed is often called a ladybird deed, and this is now just a part of our everyday estate planning for families and individuals. This allows us to transfer our house and other land and other houses to children or other loved ones automatically when we die. So it makes the house and real estate non-probate property. So we are making an arrangement to transfer this real estate outside of the probate process. And so the grantors, the person who makes the deed and owns the property, does a deed, signs it, and says, I give this house to my children when I die, but I reserve the right for me and my wife, if I'm married, to do whatever we want to with this property while we're alive, including selling it, leasing it, mortgaging it, whatever we want to do. And if we don't do something different when we die, it's an automatic transfer to whoever we name on that deed. It's a very useful and very powerful tool. It came really to the forefront in our planning around 2004 when Medicaid laws changed, and the state of Texas said they're going to come after your house if you need help paying for Medicaid for nursing home care. This takes that away. It keeps the state of Texas and Medicaid from getting the house, but it also works well in non-Medicaid situations. We often recommend people to make guidance letters, especially when they're doing something in their will that might be a little bit different. Or if they have special instructions, we would suggest you consider a guidance letter. I worked on a will here recently where a husband and wife had I think 4 children, and they left everything to 2 children. But the other 2 kids that weren't in the will were not cut out because they were estranged or have a bad relationship or they're drug addicts or something. The first 2 children were left out because mom and dad have spent a lot of money on them. They gave both of them a lot of money for a down payment on a house, each of them. They paid for school for one of them. They bought the other one a car. And then the younger 2 kids have never needed help. And so they've never spent any money on the younger 2 kids. So they want everything else to try to equal things out to go to their other 2 children when they die. Well, they need to do a guidance letter because what happens when they die is the oldest 2 kids are not going to remember everything mom and dad did for them. And so that's something that probably mom and dad could say, hey, child 1 and child 2, we love you, but we've spent money on you and we've never spent money on child 3 and 4. And we're just evening things out. Always need to review your planning every 4 or 5 years. Don't put it in a shoebox or you're safe and forget about it. And you definitely need to make changes and review it when there's a birth or a death in the family, a marriage or a divorce in the family. If somebody is diagnosed with a serious illness or somebody becomes disabled, we need to review the planning under the current laws and see if anything needs to be changed. All right, so we always need to do that. So that gets us right at 45 minutes. And so what I want to do is stop the screen share and see if we have any questions from Macy, of anybody who's asked any questions.
Yes, we have 2 questions in the chat. Are you available to see them?
Look.
under Q&A.
Yes, hold on. I can pull them up. So let's see. Can an executor of a will do similar actions of selling property, distribute assets as cash if we left those instructions in our will? Or can executors only distribute assets in the format at the time of death? This is a great question. So if we have a will and we leave instructions in our will to our executor what to do with the property, then our executor can absolutely follow our instructions. So if we say in our will, executor, we want you to take and sell our house and split the money between all three of our children equally, then our executor can absolutely do that. We can also say in our will, we want our executor to have the ability to sell the house at their option, so we can make it flexible. So we can instruct them such that they have to sell property, or we can give them the power at their option to sell the property. But we do want to give some thought to that, okay? When we write our wills, because if we don't give our executor those powers in the will, then they can only transfer the house to the three kids outright as a house. And then the kids have to fight over each other, whether or not they want to sell it. And you might have one kid that wants to live there and won't go refinance it. And so that does need to give some thought. All right. Second question. How about foreign property investments as a part of your will? Do you also need an in-country power of attorney to enforce management of these assets abroad? Or will the spouse trustee have enough power to make decisions beyond US borders? All right, so this is an interesting question. I worked on a probate just recently where a family had a flat in Moscow, Russia. And then they owned property here in the Central Texas area. Yeah, it is different. So wherever you own property at, that's controlled by the law of that jurisdiction. So in this case, these folks owned a flat, an apartment in Russia over in Moscow. We had to get and engage the services of a Moscow attorney. So you would definitely want to consult with an attorney in that country to see what you need to do to make sure your loved ones can manage it for you when you die and transfer it, and whether or not they have their own power of attorney. Definitely need to consult an attorney out of country. Now, even in Texas, though, if you own a property in a different state, right, it too is controlled by that state's laws as opposed to Texas laws. But you can and you should probably consider putting property in a different state in a trust, because all the states in the United States recognize a trust. And so if a trust owns the house, or the trust owns the farm or your vacation house, and it's inside a trust, and then when you die, the successor trustee can just take over and continue to manage it and follow instructions. So another state, yes, you need to use a trust. Another country, you absolutely need to contact an attorney in that country and make arrangements for a power of attorney and for disposition on your death. Next question, where can you go to change your power of attorney? Well, I mean, this is always an interesting question. I mean, when you want to do your estate planning, if you have a lot of time and you have a lot of resources, you can sit down and research, watch plenty of YouTube videos and read plenty of law sites and try to figure out how to draft your own power of attorney and how to customize it and do it yourself. Always, though, the easiest way to do that would be just to hire an attorney to help you do it quickly and easily and customize it. So there is no magic place to go if you don't go to an attorney. You just have to kind of go through all the different websites and try to figure out how you want to do it on your own. And you know, you hear commercials about online places that will give you forms. And I'll tell you, my experience has been that those are done right about 50% of the time. I have absolutely had wills come in that were done by themselves and were right. But I've had just as many come in and it caused problems for their family because they were not done correctly. So you kind of risk it that way. Is it okay to change lawyers when you want to review your estate planning? Absolutely. So, you know, hopefully when we do your estate plan, you feel comfortable with us and you have changes, you come back to us. That's obviously our goal. But we know that sometimes people move, for example, they might move from Waco to Austin, or they from New York City to Austin or Waco, and you need a new lawyer. We also recognize that sometimes other lawyers, their practice changes, or maybe you don't just connect well with that lawyer as well as you would like and want to talk to somebody different, or just get a second opinion. And any of that's fine. You need to hire a lawyer that you feel comfortable with, and that you want to work with. So you can change lawyers at any time to make changes. If you do a will 1 year and then 3 years later you need to make changes, you can go to a different lawyer without any problem. Of course, that's absolutely, yes, you can. If I have an existing trust created in another state, is it valid? So like I was saying earlier, yeah, it probably is valid. So I have people come in with trusts from California all the time to see me. And their trusts are often good. A lot of times I'll recommend changes to them, to the trust based on their new circumstances, based on what's happening. A lot of trusts are not well written, and so maybe they should be redone. But a lot of trusts are really well done and are good, and they suit your needs. Then you probably don't need to change them. We might want to change your pour-over will so it looks more like a Texas will, but not always. But more importantly, if you come from out of state, you definitely need to update your powers of attorney. We have different forms, different rules in Texas. Always recommend that you update and redo your powers, both your medical and durable power of attorney, your directive to physician, your HIPAA release. We would recommend you redo those so they're what people in Texas are used to seeing, and it won't give you any problems using those. So absolutely, those we recommend changing. The trust, just again, it depends on how it's written, what it does. I will tell people, when you have a trust, whether it's from Texas or another state, once you've done a third or fourth amendment to the trust, it's probably time to do what we call a restatement of the trust, and basically reformat and redo the trust, incorporate all of your changes into one trust document. Because every time you make a trust amendment, even though you put it with the original trust, it's very easy for that trust amendment to get lost on purpose or by accident. So after 2 or 3, 4 changes or amendments, we always suggest a restatement of the trust. How detailed should a will be? Like my furniture, my clothes? Okay, great question. So when we do wills and personal property items are an issue like that, we usually suggest that you do a memo to attach to the will that identifies who gets what. I want my bedroom suite to go to my daughter. I want my golf equipment to go to my son. I want my gun collection to get split between my 2 sons. And in particular, my first son gets this rifle, and my second son gets this rifle and this handgun. So we would recommend that you put that in writing in a memo, and then tell your executor how to deliver that property when you die. If you have something that's particularly valuable, though, like a wedding set that you and your husband spent $25,000 on or something, then we probably actually ought to make a specific bequest in the will and say, in the will, I give my wedding set to my daughter or whoever you want to get it. All right. Anything of particular monetary value or sentimental value, we should address as a specific gift inside the will. General stuff, I usually recommend be addressed just as a memo attached to the will. Can an executor or power of attorney be resident of another state? Yes, absolutely. Now, if you have an executor that's a resident of another state and they probate the will in Texas, they have to appoint somebody as a resident agent. And I usually serve as a resident agent for my clients that I do that for. It's no problem whatsoever. It just means that if somebody needs to sue the estate, they'll serve the papers on me as your resident agent, and then I'll send the papers to the executor, and then they'll need to call back and we'll need to make arrangements to defend the lawsuit. All right. We're currently going through a probate for mom's estate. Getting a tax ID number from the IRS is taking forever. To aid our future executor after our death, can we get our our tax ID number in advance. No, you cannot get your tax ID number of advance for your estate. Now, if you created a trust, a family trust, put everything in the trust, then yes, I think you can get it a tax ID number for the trust, but the estate cannot get a tax ID number until it's actually opened and formed in the probate process. There's no way to do that ahead of time. And yes, the tax ID number, sometimes for our clients, we can get them the same day we ask for them. And then sometimes it takes 2 weeks to get the tax ID number. It's very bizarre, but it is the IRS, right? So next question, we split time between 2 states. Do we need to have 2 different powers of attorney, guardians, etc. by state? When you're splitting time between states, this is where somebody, might consider a trust and having everything in trust, both their property in the other state and in this state. And do they need to have 2 separate power of attorneys? I don't know the answer to that question. My initial response would probably be yes. To be absolutely safe, you might have one in each state. But otherwise, maybe, what we would want to do is sit down and create one here in Texas, but maybe we would consult with an attorney in that other state, pay them a consult fee or something to clarify what their power of attorneys look like, and is there any special language that should be included, and then customize your Texas power of attorney to include things that the other state looks for, and so make it so that it would be applicable to both states. That might be the better approach, is to kind of do a combo between the 2 states so that you only have one of each of those types of documents. It was probably what I would try to do if I was splitting between 2 states. So I'd probably want a trust, and then I'd probably want to try to customize my Texas documents to incorporate whatever the other state requires in those types of documents. That's what I'd want to do. All right, guys, it's been nice visiting with you today. I think I've answered everyone's questions who posted one. We're coming right up on an hour for our time mark. I appreciate you. Or please remember, if you need a lawyer, we're out there. And Zoom sometimes isn't the best way to communicate, but with today's cold weather, it's probably nice to stay at home and do it this way. Thanks, Macy.
Thank you, Mr. Rainey, and thank you for providing an informative class today. To our attendees, thank you for being a part of this year's People's Law School. We hope that you learned something new today. If you have provided us your email, we will be sending you an electronic survey to get feedback about our program. I am also adding a link to the chat. In responding to the survey will only take a few minutes. We read every response and draw on them to plan future People's Law School programs. This is the end of our first program. If you are headed to any of the other programs today or will be staying in this room, I will be here or one of my classmates will be there to greet you. Thank you again for attending. All right, we will get started with our next session. So good morning to all of our participants who have joined us for the 2022 People Law School at Baylor Law. Thank you for being here on our Zoom webinar. This course, Elder Law, will be taught by Ms. Rainey. Before we begin, I have a few short reminders. First, this program is being recorded. Links to all of today's videos will be available on the People's Law School page. I will drop the link in the chat. Second, if you have any questions for our presenters, please use the Q&A feature to pose your questions. We will try to select as many questions as we are able to as time permits. And I do apologize in advance if we are unable to get to your question today. Finally, just a reminder, the presenters here today are not your lawyers. If you have legal issues, please consult an attorney. Ms. Rainey, if you have any slides you would like to share, and you may begin whenever is best for you.
All right. Well, first of all, can you hear me and can you see the slides? So we're good, Macy. Thank you. All right. Well, I appreciate the chance to be with you today. Good morning to all of you. I at least was disappointed when we found out that we would be virtual again this year. And sorry we can't be live in person, but given the weather outside, it's not altogether bad to be cozy at home. So hope you're in a comfortable place and ready to learn a little bit about elder law. So I don't know if any of you were in the session previously taught by my husband regarding estate planning. That topic is intertwined very, very closely with elder law and really is part of our overall elder law practice. But we're going to focus on some other issues that are within that range of elder law this morning. Now, first of all, again, my name is Elisa Rainey. I'm with the firm of Rainey and Rainey. I practice with my husband, James Rainey, and then we have some other attorneys, Sarah Kendrick here in our Waco office. We also have a Georgetown office, but our firm focuses completely on elder law. So that would include estate planning, guardianship, probate, Medicaid planning, VA benefits, a wide range of areas of practice. But when we talk about elder law, why would elder law be of interest to us in particular as a society and perhaps to your family in particular as you're facing changing needs within your own family? So obviously the number of older individuals in our society is increasing dramatically. It's projected to be at 71.5 million people by 2030, which represents nearly 20% of our population. So obviously a very large, very important part of our society, of our segment of population. Now, again, what are we talking about when we talk about elder law? Specifically estate planning, which was discussed in more detail earlier. Probate, which is the process after a person passes and we go through the court process to determine who is entitled to the property of the deceased person. Medicaid benefits, especially in the context of elder law, we're looking at Medicaid for long-term care. So nursing home care is often paid by Medicaid. VA benefits, also a valuable benefit to those of our seniors who served during a wartime period. We specifically will talk about VA benefits, VA pension benefits, as opposed to service-connected disability benefits today. Guardianship we'll touch on a little bit, and then also Social Security, retirement, and disability benefits are part of that overall elder law umbrella. We won't really go into those topics today, but they do kind of weave their way through other topics that we may discuss today. So let's start out with Texas Medicaid. And a lot of people confuse Medicaid and Medicare. So let's just kind of talk about what the difference is there. So obviously, if you've worked through your lifetime, you've paid into the Social Security system, you paid into Medicare. Once you reach 65, Medicare is probably your primary insurance. Now, if you're still in the workforce and have insurance through your employer, that insurance may be primary and Medicare secondary. But Medicare is what we're entitled to for insurance if we've paid into that system through our work life. Medicaid, on the other hand, is a state program, and we usually tap into Medicaid when we're looking at long-term care needs. And specifically think of Texas Medicaid as your state provided long-term care policy for those who need long-term care. So when we talk about long-term care, really, I want you to get a perspective of where those payments come from generally. And the payments are different if we're looking at nursing home expenses versus in-home care. So nursing home, you'll see that Medicaid pays about 50% of the costs of care for people who are in the nursing home. So a very large chunk. It's a very important benefit to those who are facing long-term care out in the community in a nursing facility environment. Other sources of payment for that care are Medicare, but we'll talk about why that's very limited. Private health insurance in some cases pays just a little bit. Private payment is the second largest payer of long-term care expenses. And then VA pays just a little sliver of that. On the other hand, if we're looking at home health care, then you'll see that Medicaid is less of an impact. It's 23% as opposed to half of nursing home costs. Medicare pays a little bit more than Medicaid does for home health. Private health insurance, private pay, VA cover the rest of it. Now, when we're talking about Medicare, some people think, well, Medicare pays for nursing home, doesn't it? Well, again, it's your health insurance, and Medicare's focus is getting someone as well as we can and back out on their own. So Medicare explicitly says that it's not intended for long-term care. So think of Medicare as rehab while we try to get somebody back up on their feet, Medicaid for long-term care. So there's the difference. And if we see somebody, let's say I have somebody with a fall or an infection of some sort that requires hospitalization. If I have someone who requires 3 midnights of hospitalization, so they've been admitted to the hospital for 3 midnights, and they go from there to a rehab facility or long-term care, then Medicare will cover the first 20 days. Again, this is after 3 midnights of admission to the hospital. We get 20 days of Medicare. And then if we have a Medicare supplement, then Medicare and that private insurance through the Medicare supplement can cover up to an additional 80 days. So days 21 through 100 are a combination of Medicare or private pay and health insurance through another source to get up to a total of possibly 100 days. Now, again, that first 20 days is pretty much automatic. You're entitled to that if you've had the 3 midnights of admission to the hospital. But once you're past the 20, then it's really kind of a probably, I was going to say day by day, but it's more of a week by week assessment of whether that individual is benefiting from rehab. And if at some point it's determined that they're not benefiting from rehab, they're going to lose the rest of those 80 days. So 20 for sure, and the 80 is very tenuous. So don't count on Medicare for long-term care expenses. All right. When we talk about Medicaid, really, again, my focus today is on nursing home Medicaid, but there are a couple of other programs I want you to be aware of. One is Community Attendant Services, often called CAS, C-A-S. That's intended to provide a little bit of in-home care for people who need support to try to stretch out their days in the home. It's not going to be full-time care by any means, but it might be 10 hours a week, 15, 30 even in some cases, but some care in the home. Also, STAR Plus waiver is intended as a home-based version of nursing home care, but again, it's not 24-hour care. To get STAR Plus waiver, it's more care than you get under CAS, but not as much as you get under nursing home Medicaid. It very much depends upon having someone else there living in the household, a spouse or children who can provide substantial support during the hours that home health agency is not there. But under STAR Plus waiver, we might get 30 to 50 hours a week of care as opposed to the fewer hours under CAS. So very important programs. But all of these programs, all Medicaid programs, are what we call means tested benefits. Means, M-E-A-N-S, tested benefits. And it doesn't mean that they're cruel or mean. It means that they have asset and income limits. So means tested. Whereas Medicare, if you paid in, you're entitled to those benefits. That's what we call an entitlement, as opposed to Medicaid, which is means tested, and they look at income and assets in part to determine whether you're qualified. So again, some basics for Medicaid, just so we're on the same page. It's primarily a state program, but it does receive federal funds. So the feds have some input into what the states can require for qualification or what they must require for qualification. It helps pay medical costs for people who meet the income and asset limits. Medicaid, because it's a state program, Medicaid varies state by state. And I want you to understand that. One of our goals today with People's Law School is to empower you to be your own advocate, but also to recognize where you need guidance from a skilled practitioner. And it is great to do research on your own. Just be aware as you're doing research on Medicaid that Medicaid programs vary widely state by state, and the rules vary widely within a state from year to year. So just be cautious that this is an area of constantly shifting sand. And so you have to be a little bit wary, always wary of what you find online, but especially so with Medicaid. All right, nursing home Medicaid, again, I tell clients we have income limits, we have asset limits. It has to be medically necessary to be in the nursing home, and most people wouldn't choose to go to a nursing home unless it were medically necessary. But the state's definition is different from what our definition might be as non-medical professionals. You have to be a US citizen or a lawfully admitted alien, and you have to be a Texas resident. Very quickly on the residency issue, there's no requirement of longevity for residency. If I move from Oklahoma to Texas and declare I am here and I am here to stay, then I'm magically a resident, and there's no wait period like there might be, like you might be familiar with for in-state tuition for colleges or something. No such requirement for Texas residency for Medicaid. But the focus is always on income and assets and determining whether someone's qualified. So let's take a look at that. The income limit varies state by state. It goes up a little bit each year. Let me back up. Income limits vary year by year, and they go up slightly each year based on the increases in Social Security benefits. So this year, the income limit for all of these programs that I just told you about, nursing home, CAS, and Star Plus waiver, is $2,523 a month gross. So again, that's pre-withholding for your Medicare B and your Medicare Part D prescription. So that's a gross limit. If we have a married couple and one of them needs nursing care, we're just looking at the income of the one who needs nursing care. And likewise, if that person's single, we're looking at their income. But there are additional income rules relating to a spouse who lives out in the community, and those can be very helpful in sustaining that spouse in the community. For nursing home Medicaid and Star Plus waiver, if we have too much income, that's an easy fix. It's what we call a qualified income trust. It's abbreviated QIT. It's also called a Miller Trust. So a qualified income trust or a Miller Trust fixes the problem of too much monthly income flow. So if we have someone with more than 23, but not enough to pay privately for nursing home care, we can still get them qualified through the use of a Miller Trust. When you're doing your own research, if you see that income limit, don't throw up your hands and say, well, I knew we weren't qualified. Please, please, please get help, and we can get that QIT in place rather quickly and fix that income issue. So income should never, ever, ever be a barrier to qualification for nursing home Medicaid, just because someone has more than that amount in income each month. Assets are more complex in the sense that we have lots of variables there, lots of strategies we can use, lots of things we need to be wary of. So let's just kind of go through some basics here with Medicaid asset limits. Single applicants can only have $2,000 in countable assets. And when I say countable assets, that's an important term. So don't lose track of that, because some assets are countable, some are exempt, and we'll talk about what those exempt assets are in a minute. But for a single person, it's a $2,000 countable limit. For a married couple who are both in the nursing home, it's a $3,000 limit for the couple. But if they're over that limit, Medicaid says, let's look at them as though they're two separate single individuals, and they each have their own $2,000 limit. So if I have a husband and wife both in a nursing home, and I move all the assets to the wife, let's say, then I can get I mean, she won't qualify if she owns all the assets. But if the husband, his assets are below 2,000 because he just moved them to his wife, then he can qualify. And so when I have two people in the nursing home, sometimes I can significantly reduce the impact of those costs just by moving assets to one or the other. More commonly, when we have a married couple, we have one in the nursing home and one still at home, taking care of himself or herself in the community. And that threshold is very different. So in that case, Medicaid says, what did they start with? So we look at what the couple started with in countable assets when the one went in the nursing home. And the general rule is we have to spend down to half. So we look at what the couple had in countable assets the first day of the first month that one went in the nursing home. We have to spend down to half to be qualified. But look at these figures on your screen here, $27,480. That's a threshold below which they don't have to go. In other words, if I have a couple who started with 30,000 in countable assets, halfway would be 15, but they don't have to get down to 15 as long as I prefer a little cushion. So I'd like to get them down to about 25 or 26,000, but technically as long as they reach that 27,480, then they're spent down as far as they need to spend down. They don't have to go all the way to half. But that second figure you see there, the 137,400, that's a ceiling of sorts for some families. And so if I have a couple starting at 300,000, halfway down would be 150,000. Well, they're not quite there because Medicaid says the general rule is that 137,400 is a ceiling and your halfway point has to at least come below that. So if I have someone who spent down to half and they're still not to 137,400, we have to keep on spending until we get down below the 137,400. Now, when I say spending, we're going to talk in a minute about what that means, but we often refer to that as spend down. That doesn't mean we just pay privately for nursing home care until we're out of money. There are strategic ways to spend. So that's part of what we'll talk about in just a moment. So again, we have your general rule for a married couple that they have to spend down to half of what they started with. We have that floor below which they don't have to go, the ceiling above which that halfway point can't be. But in some cases, we qualify for what's called an expanded spousal protected resource allowance. And that's a mouthful, but basically it means really awesome exception, because in those cases, when we have certain circumstances, specifically combined income below a certain limit, then we get to keep extra assets. And in many cases, we don't have to spend down at all because we're already qualified when we look at the numbers. We'll talk in a few minutes about how to calculate that and what that looks like. But first, again, I told you that some assets count, other assets are exempt, and those exempt assets don't code towards those asset limits that we just talked about, the $2,000, the $3,000, the half of what you started with. That doesn't include exempt or excluded assets. So let's talk about what those are. So the most common exempt assets are your house and all the land attached to it, one vehicle of any value, household furnishings and personal effects, burial plots, and irrevocable pre-need arrangements. You can sign something with a funeral home and make it so you can't cash it and get your money back. That makes those exempt. And those, I apologize, those aren't in the same order that I have them on the slide here, but again, the most common exemptions are the house with the attached land, one vehicle of any value, household furnishings and personal effects, burial plots, and pre-need arrangements. So looking specifically at this slide, you'll see as to the house, if it's if it's a married couple, so if I have one spouse in the nursing home, one still in the community living at home, or even living with the kids or whatever, they're just not in the nursing home, then it's unlimited in value. So I technically could have my house, and if I bought the house next door for my child, that can be part of my homestead and exempt. And I have a rent house next to that, that can be exempt because my house and all the land attached to it is exempt. Even if I have property across the street, streets don't interfere with that contiguous nature. They say it has to be contiguous. So intervening streets, intervening rivers or streams don't cut off that contiguity, if that's such a word. But if it's house, then somebody else's house, then my other house, then yes, that's not contiguous anymore once we get past the neighbor's property. So it can be quite expansive, and again, unlimited in value if we have a spouse out in the community. Now, if I have a single person in the nursing home, or if both spouses are both in the nursing home, then there is an equity limit for that homestead of $636,000 in 2022. And again, that goes up a little bit each year, but this year that equity limit is $636,000. And obviously for the vast majority of us, that's more than enough to exempt our home and the lot and so forth. But if we have ranch land, farmland, those of you who are blessed to have that kind of investment, those values have skyrocketed obviously over the last few years. And sometimes folks who used to feel like they had just a modest estate have a very vast estate, and it could well exceed that 636. So you would need to get specific advice on how to plan around that. Also, we talked about burial spaces. Burial funds are exempt, but if you don't have a pre-need funeral arrangement, you can also exempt a delineated $1,500 that you designate as burial funds. Obviously, if we're trying to get rid of a good deal of money, paying for a funeral is better than setting aside $1,500. But if I have someone who's just barely over that asset limit, we can sometimes say, oh, look, you're at $3,000 and we need you at $2,000. We're just going to set aside this amount and call it burial funds, and we're good. So that can be a good last ditch, last minute planning technique. The one thing that we didn't talk about yet is this last item on this list, some IRAs. So this is a biggie, and it's a fairly new development. And I say new over the last 5 years or so, maybe, yeah, about 5 years we've had this exemption. And it's still so new that we don't have written policy about it. We just have the agency, Health and Human Services, treatment of these as exempt, but we don't have a specific written policy about it. But let's talk generally about what that means. If I have someone who's reached age 72, so that's the age at which you have to take your required minimum distributions or your RMDs. Once you reach that age, IRAs are exempt. So if I have $100,000 in an IRA, it doesn't count as an asset, but I have to take my required minimum distribution. And let's say that's $1,500 a year. Then that $1,500 a year does count as income in determining whether I'm income qualified. So the account itself is exempt. The required minimum distributions are countable income. Now, let's say though that I need nursing care and I'm applying for Medicaid and I'm not yet 72 and I have IRAs, we can still make those exempt by pushing them into annuity products. So an IRA in an annuity product is exempt even if you're not yet 72. And so this is not a DIY planning opportunity. I don't want you to go out and move your IRAs to annuities solely for this purpose. Follow good, sound investment advice with the advice of your investment advisor. I don't know how many times I just repeated the word advice or advisor, but don't rearrange assets right now in anticipation of possibly needing nursing care down the road. Continue with your wise investment strategy. If we face long-term care needs, come see us or another attorney who does this kind of work, and we'll talk about how specifically to make those IRAs exempt. Now, one thing you may notice is it doesn't say 401ks or 403bs or other tax deferred or qualified retirement accounts. Those are not exempt. It's only IRAs that are exempt. So for example, if I have a 401k and I'm trying to qualify for Medicaid, I can just roll my 401k out to an IRA and it's exempt. So there are some very picky technicalities to that exemption, but it is an awesome planning strategy. And obviously for many folks, the majority of their wealth may be in their IRA. So it's a great planning opportunity for people who have a good deal saved up in their IRAs or other retirement accounts. Roth IRAs are not exempt. So it's only those from which you have to take RMDs once you reach 72. It's only those that are exempt. All right, I mentioned earlier, we were talking about that spin down strategy or that spin down requirement when we have a married couple. and we look at what they started out with, and we have to spend down to half. And in some cases, we don't have to spend down to half because the couple's income is below a certain threshold. And again, that's called an expanded spousal protected resource allowance. This is what we're looking at here. So if I have one spouse in the nursing home, one at home, and the couple's combined gross income is below this threshold, $3,435 for 2022, then we get to keep extra assets. And what Medicaid says is we want the spouse at home to have $3,435 a month to support himself or herself out in the community. Number one rule is that spouse in the community, we'll call it the community spouse. Let's just, for simplicity, let's say wife is at home in the community, husband's in the nursing home. So we want wife to have $3,435 a month to support herself, perhaps. We're not going to subsidize it, but we'd like her to have that amount. So number one rule is she keeps all her own income. Now, if she had $5,000 a month in income, that would be it. She already has her $3,435. But if she has $1,000 a month in income, she gets to keep enough of the husband's income to supplement her income to get her up to the $3,435 a month. So wife keeps her own income. If it's not $3,435 a month, she keeps part of husband's income to get her up to that threshold. But let's say their combined income is not $3,435. Then Medicaid says, okay, well, how much would they have to invest in 1 year or 12-month CDs at local rates to create enough additional income for her to get her up to the $3,435? I'm going to say that again because it's confusing. And let me see. I'm going to leave it here for a second. Wife has her income. She keeps husband's income. Let's say it's $3,000 altogether. So they have a shortfall of $435. So Medicaid says, well, how much would she have to put in 12-month CDs at local rates to create an additional $435 a month in income? Well, right now, income or interest rates on CDs are just absolutely in the ditch. I mean, they are terrible. So it takes a huge amount of money invested at a very low rate of interest to create $435 a month in income. So they get to keep, that couple gets to keep enough in assets that she could theoretically turn around and invest that money in CDs to create enough income to support herself in the community. So let's look at an example. Let's say that husband, again, is in the nursing home, wife is at home. They have combined non-investment income of $3,000. Husband technically gets to keep $60 a month of his income to support himself with toiletries and such. Let's say current interest rate is 1.19%, which I looked it up and it was when I created this slide. With those numbers, they could protect $499,000 in countable assets. So almost $500,000 in countable assets. Again, that doesn't include the house or the car or the furnishings or burial plots or pre-need arrangements or IRAs if they're over 72. It's countable assets. And so basically that gives this couple their own personal asset limit of $499,000. They don't have to spend down to half. Let's say they have $100,000, they're good. Now, if they have $600,000 in countable assets, they still need to spend down to the $499,000, but it gives them their own personalized asset limit that's different from that standard halfway spend down. So all that to say, when we have a couple with a modest amount of income, then we often can qualify one of those spouses for nursing home Medicaid very quickly, very painlessly to the spouse at home, and preserve the assets and the income for that spouse at home to support themselves, because that's a very, very scary time for that spouse when they're looking at their future, their financial future. All right, planning techniques. So again, we talk about spend down. So let's say I have a couple and they have 100,000 and we have to spend down to 50. So how do we get spent down? Again, she could, in that case, just pay privately for her husband's nursing home care. Month in, month out, we naturally get spent down because they're spending on nursing home care. And once we get to that $50,000 mark, we're there. So that is a perfectly fine strategy. It's not a very strategic strategy, but it certainly works. And very often people who go in not knowing they have planning opportunities just naturally do that, not because it was a plan, but they just accidentally did that. So spending on exempt assets would be an alternative to just the spending on nursing home care. So again, I have exempt assets, house, car, furnishings, burial plots, pre-need arrangements, and then I have all these countable assets. I'm trying to get rid of $50,000 under our example of trying to get from 100 to 50. So we can buy wife a new car. She has an older car. It's starting to have some issues. They can trade in the old car, buy a new car. She's put off buying some furniture she wanted. She's deferred home improvement projects. He's been wheeling around in the house, beating the heck out of door frames and tearing up flooring for years. She's going to get the house spiffed up. If they don't have funeral arrangements made, that is a no-brainer. Go pay for the funeral arrangements. So spending on exempt assets is a great use of money. Now, sometimes that spouse at home, they have money because they've been careful with their money over the years, and spending suddenly is very unsettling. So maybe that's not comfortable, maybe it is, but that's certainly a strategic option for getting spent down. People ask about gifts. Well, can I just gift it? And yes, we often use gifting as a planning strategy, but I want you to be aware of the impact. So when I apply for Medicaid, I have to tell about all the gifts that I gave within the 5 years or 60 months leading up to application. So I apply, and there's a specific question. What have you transferred, deeded, sold, given away in the last 5 years? So I have to report all those gifts. And when I say gifts, even sales. So if I sold my home, I have to report it. If I sold my car, I have to report it. So sometimes people say, well, what if I sell my truck to my grandson for $10? Well, that's a $10 sale and a $16,000 gift. So you can't just sell for less than it's worth. You have to sell for fair market value, or it's going to be treated in part as a gift. If there are any gifts within that last 5 years, it causes a transfer penalty, and they calculate that penalty by adding up all those gifts that were in the 5 years, dividing it by a certain number, and that tells us how many days were disqualified as a result. And this year, they divide that gifted amount by $237.93. You'll see that figure on your screen, $237.93. And so let's say that I gave away $10,000. I take 10,000 divided by $237.93. You know what? I'm going to grab a calculator. I have one here. So 10,000 divided by 237.93 gives me 42 days of disqualification. So is that going to kill me? No. Is it inconvenient and disappointing? Yes. But one thing I want you to understand is it's not 5 years. So it's not a 5-year penalty. It's a 5-year look back within which we have to report gifts, and then they calculate the penalty going forward based on the amount that was gifted in that 5 years. Now, there are strategies we can use, and really it goes beyond our time today. But generally speaking, through strategic gifting, we can generally salvage about half of what's gifted. So if I gift to my kids, let's say $100,000, and I'm going to do the math here right quick. So 100,000 divided by 237.93, that comes to 420 days of disqualification. Let's divide that by 30, get a more, it's 14 months. So if I gift $100,000 to my kids, I tell Medicaid about it, they'll say, congratulations, Elisa, you'll be qualified for Medicaid in 14 months. Well, Lordy, I need nursing home care now. That's why I'm applying for Medicaid. So my kids are out there holding my money because I've gifted it to them. I need nursing home care now, and I have a penalty period. So my kids use that money to spend on my nursing care as those expenses come due. I get credit for that, for what they're spending back on me. And through strategies beyond what we have time for today, we can salvage about half that money. And my ultimate penalty period after the agency applies those payments the kids make on my behalf would be about half the original period. So in the end, I would actually be disqualified about 7 months, not 14. And we would salvage about $50,000 of that money in the names of my kids, and they would have spent back about 50 on me. So gifting can be a very, very powerful strategy. We can preserve roughly half of what we gift. But it's a process. So it's not an instantaneous qualification. We can also use annuities in some cases. Again, not a DIY planning strategy, but if I have a spouse in the community and we're trying to salvage assets, then we can buy an annuity in that spouse's name. It would be a very short-term annuity, so it would pay back to him or her very quickly, but it's a way to get qualified quickly and salvage assets for the spouse who's still at home. That doesn't work for a single applicant. It's a spousal strategy. All right, very important topic here. I want to touch on Medicaid estate recovery because a lot of people are very wary of Medicaid because they've heard about this concept, Medicaid Estate Recovery Program, or MERP. And this is the program by which Medicaid can come back after someone has passed away and try to recover or recoup from their estate money that they've spent out through the Medicaid program for that person. In other words, let's say that I, Lisa, go in the nursing home and Medicaid pays for my care for a year or 2 years. I pass away. In some cases, the state will come in and try to make a claim against my estate, my probate estate, to try to recover the money that they spent on me in the nursing home. That's called Medicaid Estate Recovery, or MERP. Every state is required by the federal government to have a MERP program. So we can't vilify the Texas politicians for having implemented this. It's purely a federal requirement. And Texas and a few other states said, nope, 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 can't make us do it, can't make us do it. And finally, in about 2005, the federal government said, if you don't implement this program, we are going to discontinue your Medicaid funding, and that we rely too much on that for support of these services. So Texas and the other states fell into line and implemented their programs at that point. But Texas has one of the more lenient MERP programs out there. And so it does give us opportunities to plan and to still protect the homestead. So with proper planning, we can absolutely still protect the homestead from MERP. And so MERP is not a reason to avoid Medicaid. We just have to do proper planning. So very important to get good advice on how to do this. It's important to understand that in Texas, the state does not place a lien or a lend, depending on how you like to say that word. That will be a forever dispute among attorneys, but in Texas, we usually say lien. So there's no lien against the real estate. It's just a creditor's claim, just like MasterCard or a hospital, a doctor against your estate after you pass away. Now that may not get you guys super fired up, but that's an important thing for attorneys when we're looking at these topics. So no liens. And it doesn't reach probate assets. I'm sorry, it doesn't reach non-probate assets. It only comes in after those assets that are controlled by your will, or in the absence of a will, we have this state lineup of who gets your assets when you pass away, and they can come in that lineup and make a claim and try to recover. In Texas, we can avoid Medicaid estate recovery completely with what we call a ladybird deed. Now, a ladybird deed is similar to a transfer on death deed. So some of you may be familiar with one term, but not the other. There are actually significant legal differences between a ladybird deed and a transfer on death deed. Again, those differences can get attorneys really excited, but don't much make a difference to most folks who don't get fired up about those legal differences. But the effect of both a ladybird deed and a transfer on death deed is when I sign it, let's say I name my kids as beneficiaries, it is still my property for my lifetime. I still have full control. I still have full rights. I still have the right to sell it. I still have the right to give it to whomever I want to give it to. I can bulldoze it. I can suck out all the minerals. It is 100% still my property for my lifetime. But at the moment of my passing, it vests in the beneficiaries that I named in that deed. And because of the way that works, it doesn't give the state a chance to come in and try to recover from that property from MERP. And so we can completely avoid Medicaid estate recovery with the use of a Lady Bird deed or transfer on death deed. I will say that opinions differ on whether we ought to use a Lady Bird deed for standard estate planning or not. We often use them for standard estate planning for clients, not for someone, I'm 50-ish, slightly north of that, but I wouldn't typically do a Lady Bird deed for someone 50, 60, I don't know, 70 is borderline, but where they might still be moving houses and just still in the midst of acquiring and selling property. I don't know that a Lady Bird deed is the greatest plan at that age. But certainly as I have older clients who truly are in the home that they expect to own when they pass away, then Lady Bird deeds can be a very efficient estate planning tool and also a spot on Medicaid avoidance tool for anyone going on Medicaid. So very important planning technique. Let's shift okay, I do see one question. Are there any disadvantages at all to a Lady Bird deed? Can 3 or more people be named on a Lady Bird deed? What is the normal cost of going to probate court? So a couple of questions there. With a Lady Bird deed, I've had a couple of cases where someone wanted to refinance their house and the lender wanted us to unwind the Lady Bird deed in order to do the refi, and then expressly told us that we could re-implement the Lady Bird deed once the refinance was done. So it's like they wanted it off the table, refinance, or do a home equity loan, which is not my favorite. That's a whole nother topic. And then redo the Lady Bird deed. So that is one consideration. Also with a Lady Bird deed, let's say that I've deeded it to my 2 boys. I have two sons. So I've deeded it to them. By the time I pass, one of them has also passed away. That property would still vest in his estate. And if his own will left everything to his rotten, no good wife, and he's not married, so I'm not picking on a particular woman, but if his will, his own estate planning had left his estate somewhere I didn't want it to go, then that might be disruptive to what I wanted to happen with that house. So if I've used a Lady Bird deed transferring property to my kids, and then something happens to one of them, I need to redo my Lady Bird deed, and I have the right to redo it so that I don't have unintended consequences when I pass away with that property. Also with a Lady Bird deed, if I've deeded it to 3 kids and I pass, they are truly 3 co-owners in that property. And if they don't get along, that can be very difficult in getting them to cooperate in selling the property. Or let's say when I pass, one of my 3 is living in the house. We all know that situation. If we're not living it, we know it, where one of the kids has come back. And I mean, often kids living at home are working and doing great, but then you hear about those stories where you have the mooch and the one who won't get off the couch and isn't motivated for whatever reason, and they just won't move out. So the 2 are trying to sell the house, and the one says, I don't think I want to sell my 3rd interest in the house, and they can really hold things up. So if I'm wanting to do a Lady Bird deed to 3 kids and I'm not positive they can cooperate well in getting things wrapped up after I'm gone, I might actually deed it into a little trust, a simple revocable living trust, and name one of them or 2 of them as co-trustees. And that gives one or the 2 the ability to handle the sale of the house and the distribution of the proceeds after I'm gone. So don't let the fact that we have multiple beneficiaries keep you from doing a Lady Bird deed in the right case. Now, probate costs, those vary dramatically by the type of estate, the nature of the estate. Certainly whether we have a will versus not a will, it is far more affordable if we have a will than if we have an estate without a will that needs administration in the court. But I would guesstimate, it varies so much, but I would guesstimate somewhere in the range of $2,500 to $5,000 for a standard probate, and that would include the attorney's fees and the court costs and all of that. So that would be a fair estimate of probate. Now in larger counties, let's say Dallas County, Tarrant County, Bexar County, those counties, they have a different court system for probates, And frankly, it's a big pain in the backside to probate in those counties in many cases. So I would certainly expect that you would have higher fees in those counties, partly because the attorneys charge more in those counties very often, but also the process of probating is more onerous in those counties. So that's a consideration. All right, veterans benefits. Very quickly, want to talk about these. When we talk about veterans benefits in general, we have two different categories of disability benefits through the VA. One is service-connected compensation. The other is non-service connected pension. And that pension benefit is what we talk about here. We're not talking about the service-connected compensation. But in order to qualify for VA pension, it's not a retirement pension. So these are folks who just served but didn't retire. So it's not retirement. It's a pension in the sense that the VA will give someone a monthly amount of money for those who have medical needs, and the money is intended to offset the cost of those medical needs. So in order to qualify for a VA pension, you have to have served 90 consecutive days active duty in the military. It has to have been during, pardon me, a wartime period, but just one day had to have been during that qualified wartime period. And it didn't have to, they didn't have to see combat. They didn't even have to be overseas. They just had to be in the military one day during a designated wartime period. And as long as they have that 90 consecutive days, they have the requisite service period. No dishonorable discharges allowed, and there are all kinds of discharges, but as long as it's not dishonorable, then we're okay. And there are two different classes really of benefits here. One is housebound, so that's just for someone who can't get out and about and drive, but they're very independent at home still, versus aid and attendance, where the VA finds that the person requires the aid and attendance of someone else to remain successfully at home. It doesn't have to be full-time care by any means. We often get aid and attendance for people who, the kids live in a different household, but they check in on mom or dad periodically through the week and help support, maybe get their medication lined up, make sure they're getting the nutrition they need, help keep the house clean, do those kinds of things that keep the veteran or the widowed spouse of the veteran successfully at home. In the past, we've had a shift in the rules for VA aid and attendance or VA pension over the last several years. So these are the newer requirements. You can't have more than $137,000, $137,400 in total resources. That number may sound familiar to you because it's similar to that Medicaid maximum amount when we had the half spin down and you couldn't be above the 137,400. So that's likewise is the resource limit for this VA pension benefit. And that's a combination of your income, but the income is offset by medical expenses. So if I have $50,000 a year in income, but $50,000 a year in medical expenses, that's a wash. And then it's countable assets as well. So it's a combination of income and assets to determine whether I'm over that resource limit. If I qualify for aid and attendance, it's a great benefit. For a single vet, it's maximum $2,051 a month this year. Married vet, $2,431, and a widowed spouse can qualify for $1,318 for that widowed spouse. And again, that's just an income amount that comes to that individual with the intent that it helps offset medical expenses. This program is fantastic if we have someone who needs support in the home and we're trying to keep them at home. It can be used to pay family members for care. It can be used to pay an agency for care. So it's really a great tool to extend the time that those veterans or the widowed spouses can remain in home. It can also be used very well for assisted living. And frankly, Medicaid's not so great at paying for assisted living and mediocre at paying for home care. So that's where I see the greatest benefit for VA benefits. It can also certainly be used for nursing home care. But again, once we have someone in the nursing home, we're almost always shooting for Medicaid qualification for those folks. All right, I have about 10 more minutes to go. So let's try to blast through a few more topics during our time. Guardianship, I want to talk about that. So guardianship is a court process. It is a court proceeding where a court determines that a person lacks the capacity to make their own decisions for themselves and appoints someone in the position of being able to make those decisions for that individual. The one who needs the guardian is called the ward. So the ward is the person who needs a guardian. And of course, the guardian is the person appointed by the court to help meet the needs of the ward. Now, in most cases, if I have a power of attorney, if I have a medical power of attorney, and I don't have any bad players, rotten apples in that group of people taking care of me, in most cases, I won't need a guardian because I've given someone power of attorney to handle my financial matters. I've given someone the authority to handle medical decisions for me, but there are still cases where guardianship comes up. For example, let's say I've given one of my boys power of attorney, but I also, that doesn't take away my power. So yes, he can pay my bills. He can make sure everything's up and running, but that doesn't stop me from doing things for myself. So if through decline, through maybe some dementia, I become very amenable to exploitation. I've had cases where other family members are exploiting, grandkids are exploiting, charities certainly can exploit, not legitimate ones, but I'm just like giving away money. If they ask for it, I write the money. I'm deeding stuff away. I've made a really close friendship with the clerk at the local convenience store, and I'm giving away money. Then in those cases, that person who may have power of attorney may also need to be appointed as guardian, because that cuts off my ability to give away things and really puts them in a control position. So I want you to understand, with power of attorney, the person who has power of attorney doesn't control you. They have the ability to help you. With a guardianship, it gives that person more of a control ability so that I'm not giving away things at whim. Another thing, let's say I've given someone medical power of attorney, that allows them to make medical decisions for me if I can't make them myself. But the law says that if that person makes a decision for me and I reject it, I refuse it, even if I'm rejecting or refusing that treatment out of dementia, paranoia, mental health issues, if I say no, I will not do that, or I do not want that, then someone may need to get guardianship of me. So I want you to understand, though, if let's say that I have cancer and my children want to authorize treatment, and I say, no, I don't want treatment. I've seen what it does and I'm ready to go. And I have other treatment I want to use. Well, the fact that they have power of attorney doesn't give them the ability to usurp my decisions, to unwind my decisions. So I have the ability, as long as I have the capacity, to make my own medical decisions. But it's when I don't have capacity and I still won't cooperate with their decisions that they may need to get guardianship over me. And here we see that when we have guardianship, you can have guardianship of the person, guardianship of the estate, that's the person who handles property, or both guardianship of the person and estate as the need may come up. The goal always with guardianship is to use the least restrictive approach. So if someone says, I need guardianship of mom, and the judge and my appointed representatives say, you know what, Elisa does need support, but she still has capacity and she just needs someone who can help her stay on track with bills. Well, in that case, a power of attorney can do the job. And so guardianship is not the least restrictive approach. We can have a less restrictive, less intrusive approach by using powers of attorney. So that we always have to go through this analysis of what's the least restrictive way that we can get this person's needs met. And we're obligated to utilize those less restrictive alternatives as much as possible. So the goal is always to resist total disempowerment of that ward and maintain their integrity, their dignity, their independence as much as we can safely do so. Who can serve as guardian? Well, the law tells us that the spouse automatically has first rights, then nearest of kin. So that would be the kids and the grandkids, siblings, perhaps, parents. If you have no next of kin, then an interested person. So it gets really broad there. But spouse always has first rights. There are cases, though, where I don't necessarily want my spouse to be my guardian if I need one. Let's say, for example, that I have a later marriage. He was a high school flame, and we rekindled at a reunion when we're in our mid 70s or 80s. and we remarry and we're delighted in this relationship. But frankly, if I need a guardian, it might need to be one of my kids so that he's not saddled with that obligation. And so I can do what we call here, if you see on your screen, a declaration of guardian. So that says, if I ever need a guardian, this is who I want it to be. So we can use that to kind of mix up that natural statutory presumption of who can serve. But where we often also use this declaration of guardian is if we have a bad player. So again, let's say I have 3 kids and one is a bully. He's always been demeaning to me and his siblings. He has drug issues, he has spending issues, whatever his complication might be, or I just don't like him. He's been rotten since he was 14. And again, this is not, my kids are great. So that's not a reflection on my kids, but just scenarios we see. So I can use a declaration of guardian to mix it up and say, if I need a guardian, it's kid number 1. And if he can't do it, it's kid number 2. And if he can't do it, it's kid number 3. So I just put them at the end of a long list of other people. Or I can specifically say it's kid number 1 and kid number 2, and court, you cannot appoint kid number 3. And if I've disqualified someone as guardian in a declaration of guardian, the court does not have authority to appoint that person as guardian. So it's a way to completely take them out of the lineup if I don't ever want them to serve that way. All right, down to my last few minutes, I wanted to talk very briefly about rights of the elderly. And I think all of us on here recognize, perhaps in concept, even if we've never thought through it, that we don't lose rights just because we age. I mean, we have what we call, of course, we have constitutional rights and statutory rights and human rights and dignity, and those don't go away just because we age. Now, if I lose capacity to do some things for me, there are tools for other people to come in and do those things for me, but I don't just inherently automatically lose rights by age. And so there are certain protections that are built into the law, but one of these that I wanted to address specifically is discharge from a facility. So sometimes I'm working with a person who's a resident of a facility. Often we're working with their adult kids, and they get a notice from the facility, the nursing home, saying, you're out of here. We're discharging you. And so there are certain circumstances where a person can be discharged from a facility, and I want to walk through those quickly. So a facility may not transfer or discharge an elderly individual from that facility unless the facility cannot meet the patient's needs, or the patient's health improves and they no longer need those services, or the patient's or another patient's health and safety is endangered. Think dementia. I get violent, I get aggressive, I push somebody down, I'm aggressive towards the nurses. That's where this would be relevant. The facility ceases to take the program through which they're being paid. I'm on Medicaid, they quit taking Medicaid, they can discharge me at that point. Or if I fail to pay. So if I go in, I say, yeah, I'll pay. And I get there and I just don't pay. And I don't pay and I don't pay. Maybe it's because I'm stubborn. Maybe it's because I have dementia and there's nobody out in the community who has the power to pay for me. So that can be one of the factors. Now, once I've applied for Medicaid and that Medicaid application is pending, they cannot discharge me while the application is pending. But then if I get a denial, then they can discharge me. Now, they have to give me 30 days notice that they're going to discharge in most cases, unless it's a health and safety issue. So again, if I become aggressive, they don't have to wait the 30 days. If it's a pay issue, then they do have to give me the 30 days. Oh, that was all me, sorry. Well, heck, I messed up my display. Okay. Okay, we're just going to abandon the display. Hold on, I'm going to stop sharing. I think I've already stopped sharing, perhaps. There we go. We're going to stop sharing. All right, so they have to give the 30 days notice unless there's some kind of aggression or health issue, and then they can discharge me without that. Maybe it's not that I'm aggressive. Maybe I'm a wanderer. I have dementia and I just keep making my way out the door somehow and they can't stop me. Well, that's a health issue for myself, and they can discharge me without the 30-day notice. So just be aware of that. When you are working with a loved one who's in a community, a nursing community, and maybe usually the issue comes up over pay, but make sure that they are complying with any requirements they have. And often if they're discharging and they haven't given the 30 days notice, just holding their feet to the fire on that 30 days is enough to get the things resolved, because we want someone to be in a stable environment. We're not wanting to move community to community, but we also want to make sure the facility is getting paid. So it just gives us breathing time to get things worked out. So be aware be aware of those rights. All right, I think that is all I had on my slides. Let me look right quick. If I have, Macy, do I have a moment to look at this other question that we have here?
Yes, you can.
Okay, give me just a moment, and I'll just read this out loud. If the parent has been under the care of the adult child for the last 10 years because of dementia, and a review of assets needs to be done, but the parent has maybe 10,000 in the bank, no will, and no assets at all because he or she is 80 years old, will a review be done about the caregiver child possible contributions ever? That sounds very specific. That sounds like a particular case. And I am not comfortable giving particular advice on a particular case. So I will decline to answer that right now, but I do recommend that you get an attorney to directly look at all the circumstances in that case to see what can be done to protect the interests of that senior. So thank you so much, very much, for letting me join you this morning. I hope all of you enjoy a cozy day indoors today. Macy, do you have anything else for me?
I was just going to end with some closing remarks if you're done.
Okay, I am done.
All right.
Thank
Well,
you.
I just want to first go ahead and say thank you so much, Ms. Rainey, for being with us today. And thank you for providing a very informative class. To our attendees, thank you for being a part of this year's People's Law School. We hope that you learned something new today. If you have provided us with your email, we will be sending you an electronic survey to get your feedback about our program. I am also adding a link to the survey in the chat. Responding to the survey will only take a few minutes. We read through every response and draw on them to plan future People Law School programs. This is the end of our second program. If you are headed to any other programs today, or will be staying here, either I or one of my classmates will be here to welcome you and assist you in any way we can. So thank you for attending, and thank you again, Ms. Rainey.
Thank you, guys. Have a great weekend.
All right, let's go ahead and get started with our last session for today. So good morning to all of our participants who have joined us for the 2022 People's Law School at Baylor Law. Thank you for being here on our Zoom webinar. The course Top Scams During the COVID Pandemic will begin shortly, but first I have a few reminders. First, this program is being recorded. Links to all of today's videos will be available on the People's Law School page. I will drop the link in the chat below. Second, if you have any questions for our presenters, please use the Q&A feature to pose your question. We will try to select the questions that are likely to be most interesting to the most of our participants, and we will do our best to get to as many questions as we can. I apologize in advance if we run short of time and are not able to answer your question. Finally, just a reminder that the presenters here today are not your lawyers. If you have a legal issue, please contact an attorney. And today our class will be brought to you by Professor Nichols. So Professor Nichols, if you are ready and have any slides to share, you may do so.
I have no slides to share and I am ready to go whenever I'm permitted.
You can go ahead.
All right, welcome everyone. So I'm Professor Nichols, I'm Connie Nichols. I've been here at Baylor for actually this month 14 years, and my practice area and my teaching relates to intellectual property as well as to cybersecurity and information privacy. So I thought it would be a great topic to talk to you all today about the top scams online during the pandemic, as well as to give you some tips on how to prevent your risk of being a victim to these cyber crimes. So first of all, prior to the COVID pandemic, cyber fraud was increasing at record numbers. The access to digital information was constantly being compromised, and the pervasiveness of this is because cyber criminals are constantly evolving their attack methods. Now, with the pandemic, with so much activity now online, it created a new opportunity for these cyber criminals to truly get involved and take advantage of the anxiety that was created by COVID, as well as the technological issues that those who are new to technology may have encountered as a result of going online. So let's talk about some of those scams and how you might prevent yourself from being a victim. All right, so I just saw a comment regarding the actually seeing me versus the slide. Is there any way that we can change that?
Yes, I will work on that.
Okay, perfect. All right, thank you so much for that comment. I had no clue that you couldn't see me. So the first thing I want to talk to you all about are these offers. So offers that are coming via text message, offers that are coming to you via your email, and of course, you may get someone knocking at your door with offers that seem to be too true. The fact of the matter, they are too true. They're unbelievable offers, and they're probably going to be offers that are scams simply to obtain your information. Now, one of the things I want you to think about is the types of text messages that you're receiving. These text message scams really start to look like things that are happening in your everyday life. For instance, you'll get a text message from Amazon about a $50 gift card. Well, if you all are like me, during the pandemic, Amazon became my best friend and confidant. And so having a text message to come from Amazon didn't necessarily seem suspicious, but the offer within that text message was very suspicious. So do not respond to any offers that seem too unbelievable. If they're too good to be true, odds are they are a scam. Secondly, the biggest just overall scam during the pandemic, and it has remained the biggest scam just generally online, are phishing scams. And so phishing scams use fraudulent emails. They can also use text messages as well as phone calls, where they attempt to trick you that they are a reliable source to gain information. So if you are receiving any text messages that you aren't expecting, that include a link or that require you to log on, please do not do so, because odds are that is a scam. So don't click on any links, and really, truly don't open any emails that you're not expecting to receive, or emails that seem suspicious. When I say seem suspicious, is that they're coming from, or they appear to come from, a reliable source, so your boss. But your boss knows that you're not referred to as William, but rather you're referred to as Bill. And the introduction says William, and there are typos, or the language just doesn't seem like your boss's language. That is a phishing scam, and they are there to acquire information. So don't click on links, and never provide your password to anyone, passwords or account numbers to anyone that you have not verified really need that information for a particular purpose. So phishing scams, the largest. Now, this one is interesting because cyber criminals really are smart. They read the news and they understand how to acquire information that can be used to access your accounts in a way that you're not expecting. So the most current scam that relates to COVID generally is relating to the distribution of free COVID tests, distribution of those COVID tests, and the distribution of N95 masks for free. What these cyber criminals have done is they've captured this headline, and then they'll send you an email, or it'll appear on your social media link for you to click on and sign up to receive your free COVID test. Here they're getting all of that information that's going to be necessary to access your accounts. So we really want to curtail that by, number one, visit only official websites to gain information on how to acquire your free test, your N95 mask. So go to the CDC, go to the World Health Organization's webpage, but ensure that you're not clicking on these links that are going to ask you for an exorbitant amount of information that is going to be used to compromise your account. Interestingly enough, in addition to really thinking about the headlines, cyber criminals have really preyed on the anxiety of consumers with respect to the availability of funds through traditional banking. So this is an opportunity that these cyber criminals have taken with respect to cyber crimes, right? So if you read the headlines, you're hearing and learning about a number of organizations that are being compromised due to these cyber crimes, and the criminals are smart. They are using that information to then seek additional information from you. So one of the newest crimes happens to deal with financial information and banking. Of course, in Texas, There was an issue last winter with respect to the power grid. People were at home due to COVID. And one of the scams that has occurred is indicating that your money is not safe in a traditional bank. And that in order to ensure that your money is protected, we're going to want you to move your money from your traditional bank and deposit money to some other source. One of the things I want to alert you to is that if your money is in a bank, it is safe, it's federally insured. And so any issues that you would have with your money in the bank, it's insured. But cyber criminals are targeting that anxiety. And because of that, if you get any notices from your bank that you're not expecting, please ensure that you contact your bank prior to an attempt to log on. The last scam that is prevalent as a result of the pandemic is the request for donations for particular charities. So prior to you donating any money, really do research about the organization. Again, it's pulling on the heartstrings and anxieties that we've developed as a result. And be wary of any business or charity that is requesting COVID-19 related payments or donations in cash, by wire, or gift card, or any of those things through the mail. So those are the top scams and things to look out for. But really, truly, how do you protect your information just generally now that you're aware of the scams? You know that if it sounds too good to be true, it's too good to be true. You know now not to open any emails or text messages that have links that you're not expecting. You know now to be really cognizant of the ways in which you receive emails. You know that your money is insured and safe in your bank, and that you should go to official sources with respect to any type of COVID programs that are official and sponsored by the government. What else can you do to ensure and reduce your risk of becoming a victim of a cyber fraud? So the first thing I want you all to do is to continually update your computers and your mobile devices. Cyber criminals frequently gain access to your information because they know the flaws in the particular software and operating systems that you're running your computers. And the updates patch these flaws. So one of the things I really do want you to do, and I know that it is a daunting task when you sign onto your laptop and it says there's an update, please update it. The same thing goes for your cell phone or your mobile device. They have access to that. It is a computer. And just like a computer, your mobile device needs patching sometimes. And please ensure that you update. Now here's the good thing. A lot of the operating systems and mobile devices have the ability for you to set automatic updates. So I want you to start thinking it's a chore. Update, because that's the best way to protect your information now that you're online more frequently. So rely on the programs that are offered for patching and updating your systems. The next is one that's simple, and I hope you all have this, but really do employ antivirus software. While it's not one of the top scams with respect to viruses being introduced, but these phishing campaigns can introduce viruses. They can introduce viruses, they can introduce keyloggers where they're able to see what you're typing and gather your passcodes that way. So one of the things I want you to ensure is that you have an antivirus software and anti-malware protection on your computers. If you do not, please do stop and take advantage of some of the antivirus software that's available. And almost all internet service providers offer a free subscription to antivirus software. So contact your cable company, your wireless company to see what type of antivirus software they offer with respect to your home computers and devices for free. Now, just this morning, prior to logging on, I received a notice from my credit card company, Discover, that they have found my Social Security number in a database. Now, I have a question for you. Did I open that email? Anyone? Raise your hand. I didn't. I wasn't expecting an email from the credit card company. I wasn't expecting to find anything about my Social Security number. So what I did is what I've advised each of you to do is to log on, look into my messages on my banking account for my credit card, and I discovered I had no messages. I then reached out to Discover Card to provide them notice that there is this scam indicating that your Social Security number has been found in a database. And I forwarded a screenshot of that to the bank. So again, don't open any of these. But here's the deal. Passwords and Social Security numbers are constantly being compromised. So how do we protect ourselves from that? Well, we really can't protect ourselves, but we can reduce the risk. So I want you guys to just like really embrace the fact that at some point your information will be compromised, because the cyber criminals are smart and they are working around some of this technology. So what I'm here to tell you is how to reduce some of those risks that are associated with the acquisition of your information. So passwords, do not repeat your passwords across multiple websites. If you have your favorite passcode and you want to use it for absolutely everything, that's a problem. Why is that a problem? Because if that password is acquired by one in one malicious attack, now they have access to all of your information that uses that password. So don't repeat your password across multiple sites. Change your password frequently, and I recommend changing your password every 3 to 6 months. And then create a very strong password, which is very difficult for individuals to guess. Now, if you use social media, there are things on social media that can key a cyber criminal to your passcode, as well as to your security questions. So if you're on social media and you have your birth date, your high school that you attended, your location, your occupation, oh my goodness, you've just given away your life. Because if you think about your security question, what normally is it? High school mascot, right? So we're going to want to think about the amount of information that we're disclosing that's freely available to cyber criminals in addition to ensuring that when we create passwords, we don't create passwords such as Raider 1975, right? So don't do that, because someone can guess it based upon the information that you freely disclose publicly. All right. So I've told you now not to repeat your passwords across multiple websites and multiple data management, and that you should change your password every 3 to 6 months. One of the things that I also recommend is to keep up with all of that. Use a password vault where you can securely keep your passwords in one place. And password vaults are programs that are available for mobile devices and computers where you can truly keep record of it. Because if any of you are like me, I'm like, oh, I think that's my password. And then that's not my password. So really do try to keep up with those, and getting a password vault is highly recommended. All right. My next tip for you is to back up data on your computer and your mobile devices. This is going to be important because, again, even the best system can be compromised or crash. So regular backups are going to enable you to recover your information if there's a problem with a particular system. You can easily back up your mobile devices to cloud storage space. Even Google Drives, you can back up your information there. But again, use some caution when sending any type of financial information into cloud storage and backing them up there. Because again, no system is without flaws, and you don't want your financial information compromised. My next tip to you all to reduce your risk of information being acquired through scams, as well as just through cyber attacks, is to talk to your children and family about internet security. When we're all vigilant, it makes it easier for us to reduce our risk. If you have young children that use the internet, they are vulnerable even to the most basic attacks. If you have senior members of your family that are online and this is new for them, then again, they're not as savvy and are going to be vulnerable to some of these basic attacks, such as opening the links and providing the information because they believe it to be a trusted source. So my last tip to you all about protecting your data and avoiding these cyber crimes and cyber scams is to know what to do if you become a victim. So if you discover that your information has been exposed, you may want to enable a fraud alert or credit freeze on your credit information. A fraud alert on your credit reports requires all potential creditors to contact you and obtain permission to open any new account or line of credit. So a fraud alert is going to require creditors to contact you prior to opening any of accounts or new lines of credit. A security freeze is slightly different. It may help to block institutions or lenders from accessing your credit report unless a preset PIN is provided to you to thaw the report, which prevents them from opening accounts in your name. So really do be vigilant if you believe that your information has been compromised. Consumers are entitled by law to receive a free credit report from each of the credit reporting bureaus once a year. You can go to annualcreditreport.com to get this, but take a look, see what's there, see if you notice any accounts that you didn't open. You will be surprised how your information could be compromised and you not know. And again, don't hand over information freely. If you do become a victim, you realize the type of fraud that's happened, please report. And you can make a report to the Federal Trade Commission about any cyber risk that you have encountered or if you become a victim. So again, know what to do and report. Are there any questions? There's no questions?
If you have a question, you can drop it in the Q&A function or the chat.
Well, seeing that I have no questions, I see a question. Question, how do you clean up your credit report if you find yourself a victim of one of these scams? Oh, that's an excellent question. And when is it appropriate? I have two questions here. When is it appropriate to contact the law enforcement? Okay, so if you believe that your credit report indicates that there are files there that you've not opened, this is the perfect time for you to contact law enforcement. What you're going to want to do here is to get a police report indicating that you have been the victim of what's called identity theft. And it's going to be really important that you have this police report because that's going to help certify that you are you and not the individual that's committed the identity theft. So if you find this on your credit report, then you're going to make a report to your local law enforcement. You're going to get that police report, and then you're going to use that police report to have all of those accounts that have been open removed from your credit report. If the information that has been acquired is any type of information, say for instance, that is trade secret information about your employer, then you're definitely going to need to alert those individuals, as well as waiting for them to indicate to you how best to move forward. One of the things I want to tell you is, again, if you're working and your work computer is compromised, you're going to immediately want to contact your IT, and then they can advise you on how best to move forward. Should you also notify the Social Security Administration? Absolutely. If your Social Security number has been compromised, the answer to that is yes. And again, one of the things that's really nice is to put this fraud alert and credit freeze on your account once you realize that there are issues there. And here's the deal with this. This is an absolute nightmare to deal with. So the best way to work work through this is to minimize your risk by really truly following some of the simple things that I've said. Don't use the same password. Don't freely give out your social security number. Ensure that anytime that you're applying or providing your information, it is a trusted source. Update your mobile devices and your computers to ensure that you have the proper patches such that malware and other attacks are not happening. And then again, just be vigilant. Don't open links that you don't trust or you're not expecting. And don't go to websites and download websites that are iffy, right? If they feel weird, don't do it. Even if they pop up on your social media. I get all of these suggestions on Facebook. I don't open those because, again, they could be malicious. Are there any other questions or anything you want to know about protecting your information online and avoiding cyber crimes before we end for today? All right. Well, I want this to be your takeaway. If it is unbelievably great, it's unbelievably great. Just don't believe it. Thank you guys for attending. Have a nice day.
Thank you, Professor Nichols, and thank you for providing such a great and informative session. To our attendees, thank you for being a part of this year's People's Law School. We hope that you learned something new today. If you have provided us with your email, we will be sending you an electronic survey to get your feedback about our program. I am also adding a link to the survey in the chat. Responding to the survey will only take a few minutes. We read through every response and draw on them to plan future People's Law School events. This is the end of the program and our last program for the day. So I believe that is all we have for you. I hope you've enjoyed your time with us today, and thank you so much for attending, and thank you again, Professor Nichols.